Welcome everyone. Today we have a wonderful presentation by Dr. Arathi PM on the topic preventing domestic violence, patriarchy, law and judiciary. Dr. Arathi PM is assistant professor at the School of Indian Legal Thought, Mahatma Gandhi University, Kottayam. She completed her doctoral research on the topic gendered bodies, medicine and law, a study of selected case laws from India, and an MPhil dissertation on the topic Aborting Gender Justice, Legislating Abortion in Selected Countries of South Asia, a preliminary analysis from the Center of Social Medicine and Community Health, School of Social Sciences, Jawaharlal Nehru University. She has done her master's in law with healthcare laws as specialization. She was a global fellow at Berlin's Social Science Center, funded by WZB and International Social Science Council, Paris. Her postdoctoral academic work and publications cover the area of public health laws, the politics of reproductive technologies, social determinants of health, feminist jurisprudence, and the regional modernity of Kerala. She has co-edited Universalizing Healthcare in India, Journey Through Time from Care to Coverage. And most recently, she edited Public Health in India, Policy Shifts and Trends. Before starting the program, all the participants are requested to keep your microphones on mute for the duration of the presentation. Please type in your queries and comments in the chat box. We will read them out at the end of the presentation. I invite Professor Arunima, Director of KCHR, to preside over the session.
Thank you, Fashia. On behalf of KCHR and personally too, I am delighted that we have Arathi with us today. Arathi has been working in this area for a very long time. I remember actually very vividly listening to her interventions in JNU when we had, as part of our own center, invited her to speak on a similar theme many years ago, actually. So I'm really very happy that we can host her here today. And the area that she is dealing with is of immense importance in the context of Kerala and the country, as we know, in fact, the world. Domestic violence in its various forms really affects women, be they spouses, partners, or even family members, meaning natal family members. So therefore, this is an area of extreme seriousness. And we are very lucky to have somebody like Arathi who combines different kinds of knowledges about this. She's trained as a lawyer, but she also comes to this theme from the angle of somebody who has worked in the broader area of social medicine and those kinds of concerns. So very welcome, Arathi, and we really look forward to listening to you.
Thank you so much. Thank you, Arunima, Fashia, and I miss Rachel today. So the entire team, first of all, having this series on scholarly reflections on contemporary issues and the KCHR's interventions, I really appreciate. And I used to be part of most of your online webinars and presentations until we started completely to the offline mode of teaching. So now this has become kind of a difficult situation when it happens in working days and this time, not. But thank you so much. And I just want to, as an introduction, I want to say that this is something which is actually not a sole academic work of mine. And the inferences I use in this paper today, which is mostly coming from the everyday courtroom experiences. So I just practiced for a very short while long before. And my twin sister, she is a practicing lawyer in Calicut, and right now she is a government leader, and she has been working ever since the Domestic Violation PWDVA Act implemented as service provider, as a lawyer. So most of the experiences, lower courtroom experiences, comes from my field work as well as the inputs given by Agra. So I acknowledge her academic input in the presentation. So I have a paper. So I think I'll just go to the presentation and we can have a discussion at the end of it. But before I begin, I just want to flag in one point. Usually our understanding of law, legislation, and our sense of justice, which is very popular sense of justice, which is like law shouldn't be biased. So it has to be value neutral and balanced and all. But probably, I think this is preventing domestic violence in India. This legislation is probably the one of the first legislation. At the beginning itself is stated that it's a biased legislation, the bias towards women. So that is that makes the legislation something unique, and I just would like to flag in at the beginning. And let me do a presentation, and at the first part of my presentation, generally looking into the concept of domestic violence and how as a legal category it has been evolved, and the journey of legal category of the concept of domestic violence. And second part of my presentation, I'll be mostly focusing on the experiences of it from the lower courtrooms, because most of the legal papers, academic words which are familiar to you, might be referring the Supreme Court cases and upper court, higher court cases, because the verdicts are available as a primary document to many of documents to many of us. But when it comes to domestic violence, you know that the cases contesting in the which is reaching to the apex courts might be a rarest of rare incident. So there are a very limited number of cases which got contested in the higher court. So I think it's very important to understand the lower courtroom experiences when it comes to matters like the everyday lived experiences of women and the question of domestic violence. Social construction of home as that of a space of safety, but it turns to a place of violence, as Molly Warrington argues. Till recently, violence occurring in private space like domestic atmosphere was generally considered as outside the ambit of public concerns. In the last probably more than 1 decade, there have been public debates on this idea and demands for regulation of violence in the domestic place. A Caribbean study by Lazarus and Black about the limitation of domestic violence law as a symbol and instrument of social change, I caught here. For the first time, violent words and acts that formerly remained unspoken, invisible and irrelevant to the project of state became highly conspicuous and subject to immediate legal sanction. So this study further examines, in the context of Trinidad, a lower court are managing state's entrance into the formerly private sphere of familial violence, and how in turn litigants and legal professional kinships and gender ideologies and action transform legal processes. So in this paper also, I will be mostly looking in a using a methodological framework towards that direction. So it's in Indian context, it's a widely acknowledged claim of the Ministry of Social Welfare and Women and Child Development and many of women's movements in India that people of India have acquired the right to approach to the court to seek protection against a violent or abusive family member or from a formerly intimate partner. A consensus is forming internationally regarding the causes of domestic violence. Probably last 2 decades, that consensus has been forming. That domestic violence, that personal, economic, social, and cultural factors combine to the domestic violence, which constitutes the basic category of domestic violence. Representation of home as a masculine space is being widely discussed in feminist literature, we know. The notion of home as a primary site of violence is being challenged with specific questions like why women remain in abusive situations for many years. If you're familiar with the work of Kirkwood, which remarks, women are bound into web of emotional abuse and physical violence, which reduces the resources on which they might draw to challenge their partner's control or leave an abusive relationship. And the works of Williams, which locates the shifts at the beginning of 18th century from home as a productive and reproductive unit of society to one that is largely a means of reproduction. In a number of ways, family has stood at the center of capitalist society, he further argues. The work of Dorothy Smith, she argues that the idealization of the family interprets the violence as a legitimate male response to female faults. So now also we can see that that reflection you see when in the NFHS data set, which asks the question whether is beating of women or violence from the part of the husband is right or not. So I always think why that question exists, from which kind of an understanding or a popular notion that question itself is coming into the questionnaire of NFHS. So the structure of institution of marriage, which legitimizes the use of violence to enforce male control. I would like to say that this is not a popular kind of an understanding within the judiciary also. When the 5th year of PWDVA Act came into existence, in one of the training programs of judicial officers, there was a question, is it right to beat the wife? So then 64% of the judicial officers are having the opinion that it's okay to beat the wife. So that's the kind of an understanding the judiciary itself is having. So as a violence to enforce the male control, so that's become kind of a, that's where the family gets fallen down, I feel. So I would like to quote Molly Warrington once again here. The definition of domestic violence is one that encompasses verbal abuse, intimidation, and physical harassment and assault. Although there are physical violence initiated by women, the overwhelming majority of perpetrators are men, and the violence perpetrated by men on their wives, partners, and close relatives. So when you, nowadays you can see that a lot of works in the context of criminal jurisprudence and gender neutrality of criminal jurisprudence is coming vehemently argued by many of the legal scholars, and they are arguing that the always imagining perpetrators are as male is problematic. So the legal language has to change to be gender neutral, to be inclusive of women also. So wives also, husband beaters can also be there. So that is one of the arguments emerging in the legal field nowadays in the name of neutrality. I'll come to that later. So the most common type of violence against women is domestic violence perpetrated by the intimate partners or the ex-partners. In India, most of the knowledge related to the violence against women is produced as part of activism by women's movements, including autonomous women's movements, the works of Bandana Purshayasta, which is clearly shows how the knowledge being produced by the women's movements in India. So Purkayasthas and a group of authors, they are arguing that the feminist literature definition of violence against women, I just got here, any form of coercion, power or control perpetrated against a woman by her intimate partner or his extended kin, and includes physical, sexual, verbal, and mental abuse. So in this paper, I tried to understand how judiciary deals with domestic violence cases as an everyday basis in lower courts. So this paper tries to understand the socio-economic underpinning of domestic violence cases specific to Kerala, and what is the nature of violence? How is judiciary treating different cases of violence newly acknowledged through the introduction of protection of women from domestic violence against women, Act of 2005, PWDBA. So how do women from different backgrounds internalize their encounters with judicial system in their legal battle against violence within intimate relations? So that's one of the focus of this work. How does this experience help women to face world differently, or does it help them to think in terms of being part of movements or movements for emancipation? Does this act bring any changes in the attitude of institutions like police and judiciary while dealing cases of domestic violence? Does this act give remedies to the needy people? Is it important to explore the courtroom experiences, since PWDVA is the outcome of battle of many of the women's movements and NGOs and women's rights initiatives? So methodologically, I would like to focus a few minutes on that. The regulation of intimate family relationship to control and prevent violence against women in domestic spaces, analyzed as an instance of interference of the instrument of the state to regulate and monitor hitherto private space. To what extent can the interference of law help suppress women to use law as a tool to change situations of familial violence and thereby enhance their capacity to engage with the male space of courtrooms? So there's tension between the feminist ideology and law. It's like an ongoing one. It has been happening for quite probably from 60s onwards. So whether law, can we see it as a tool to oppress the women further, or is there any emancipatory potential to law? That's the basic kind of an debate it has been going on. So the result from the legal and judicial process may not give solution to the violence. This study indicates that they have probably whatever they've underwent, but the courtroom and the client counseling experience reveals that it provokes women's mind to think in terms of emancipation, because they completely go through a process of understanding that the futility of the entire role of law itself, and thinking about the alternative forms of solution seeking, the way how to get over it or how to deal the violence in a better manner. So the diversified feminist understandings of law as a means of oppression or tool for emancipation is complex in a semi-feudal, patriarchal, post-colonial society, as the case law based on this PWDVA suggests in this paper. So the everyday practice of domestic violence in lower courts is analyzed primarily on the basis of experience of a practicing lawyer working, and the interviews in the working in the lower court in Calicut, Kerala, and she has been the service provider for PWDVA. So the interaction with other service providers from different parts of the state also help to improve the understanding in this matter. So the information gathered is primarily from the clients from Family Counseling Center, Calicut, and family counselors and the legal counselors from the service providing centers established under PWDVA, and the present and former protection officers under PWDVA, police officers from different police stations, Chevayur, Panningara, Kondoti, Nadakkav, and Chamanad. So the interaction with lawyers of respondents and the judicial officers of the first class judicial magistrate court Calicut helped to gather many of the information used to formulate the understanding of this paper. The case reports and monitoring and evaluation reports of PWDVA prepared by Lawyers Collective from the year of 2007 to 2015, and the landmark judgment cited in Lawyers Collective website also being used for shaping the sharpening our argument. So in this paper, the tension between the law and the emancipatory potential, which is not, there are a lot of vast area of theoretical debate on violence against women and the role of legal control. All the arguments, observation, and findings in this paper related to the lower court experience are related specific in the context of Kerala, and we do not. I don't want to generalize in the pan-Indian context, but however, I think one can trace certain similarities. This paper discussed domestic violence in the dominant heteronormative framework primarily, but I do acknowledge other kinds of domestic violences which fall under the fall outside the framework of heteronormativity. Victim or women's agency and the complex production of agency in the lower court also is not really dealt in this paper. So this is the methodologically, I just want to state it as the beginning of my presentation. So now I think we are almost reaching 2 decades after implementing PWDVA, and the approaches on the operational level is examined in this paper. Of a number of registered cases is the sole criteria to evaluate how this act functions at official levels. How many cases registered under the PWDVA Act? That's how they officially we assess how effective the legislation is. But if you starting from 2005 to 2016, 17, and into the 2000 till 2021, the statistics shows that a steady increase of reported cases in the context of Kerala, and we don't have much of the data from the other state outside Kerala. So I'm relying on the statistics available from Kerala. These numbers are influenced by a number of factors, including how the act itself is implemented in Kerala in a different manner. The protection officers, the service providing centers, the police and the magistrate, the scope of interference by the vigilance committees in panchayat level vigilance committees, and the role of local self-governing bodies, and the extent to which these bodies utilize these possibilities. And we can see that the work of there are quite a lot of work which is discussing about how the courtroom experiences is different in different contexts. The work of Ahuja, which cite a similar social condition of subordination of women in India while mentioning the link between attitudes of indifference and negligence and the general acceptance of male superiority within the judiciary. So Kerala, when in 2005, when the act came to existence, and now also is the only state that provides each SPCs with a practicing women advocate as the legal counselor. So the functioning of special protection centers is regulated by Social Welfare Board under the Ministry of Social Welfare. So the board transformed family counseling centers to SPCs. However, many court centers do not have SPCs. Majority of the 72 SPCs in the state have an urban base. So access for a complainant from a rural area is virtually little difficult here. So in cases where the complainant gains access to SPCs, there is a question of whether they provide an ambience of free disclosure to the complainant, whether how complainant friendly are these SPCs. Even so, the influence of the definition of violence under this act on the complainants is noteworthy. The understanding of what all constitute violence slowly opens up to the disclosure of their cases. Solutions are attempted through family counseling, and I'll come to the issues related to that later on, and how these tensions of the reiteration of patriarchal values happening through the family counseling, which is a major concern mentioned by many of the scholars later on. So in a span of 17 years, protection officers started functioning in all districts of Kerala, and protection officers are appointed here on a permanent basis. But their social and gender sensibility, it's at times very problematic also when we have interacted them with in a closed circuit. So is it possible for the act to achieve its potential when the officers functions mechanically and in the absence of a gender sensitized attitude? The officers needs to be mentally prepared to cope up with the round-the-clock demands of the office and its constant responsibilities towards the complainant. So this is very often not the case. Then we heard a lot from the complainants how ineffective at times the interaction with the protection officers. So there are many instances where the cases of domestic violence are dealt by the police rather than SPCs and the protection officers. So in the space of verbal and emotional aspects of violence, which are not recognized in their complexity and outside the scheme of institutionalized power relationships. So they are dealt with the practiced kind of a manner. The police still show reluctance to register the cases under the violation of protection under section 33, 31 and 32, even assume the role of counseling officers, bypassing the act, SPCs and the protection officers. The police and the complainants lack awareness that violation of democratic rights within the family space is not to be dealt within the police station. So this reflects the ineffectiveness in the implementation of the act to an extent. So the entire, we have a better system in Kerala, but still that system is kind of perpetuating the popular values, more especially the moral values perpetrated through the patriarchal attitudes. So there are so many instances where women came to complain, and the police officers will try to say that, okay, this is something you shouldn't be going to the court to resolve such silly matters. Let you just talk to your husband and then just resolve it. So how this the entire notion of violence is internalized by the system, and how the Domestic Violence Act is conceptualized, that you can see a clear conflict between the two. Let me just quickly mention the socioeconomic background of most of this domestic violence complainants in Calicut, but I think we can see that a lot of there is cutting across of class and caste backgrounds. We can see a lot of complaints coming in, but the Family Counseling Center of Kozhikode are the SPCs that dealt with the highest number of cases in Kerala. Around the majority of cases came from lower or lower middle class background, where family income is generated from daily based labor. Majority of the women are not engaged in income generating labor. So in few cases where they are, the employment categories include those like salesperson or NREGA worker or domestic help. or around 10% of the middle income bracket, that includes government employees and teachers and high income generating to like NRIs. So violence against women is increasingly considered as one of the concerns of public health as well. So the study of low income communities and violence tried to reinforce understanding that low income group experiences more violence, which creates a popular understanding that in upper class violence is less. However, we can see that there's no study which deals with reasons, the linkage between the poverty and domestic violence among upper class families. All the estimations are based on reported cases, and it is important to look at what makes the difference in rate of reporting or degree of secrecy rather rate of incidence. So it's not about the reported cases. We have to look into to the question why there is a secrecy, degree of secrecy, or lack of reporting as well, when we have to see the linkages between the class and class status and the incidence of domestic violence. This is in terms of reported cases, and the its correlation with the class status. So there are a lot of studies in different settings argue through the physical violence against women cut across all socio-economic groups. Women live in poverty are disproportionately affected, and primarily maybe underreporting among upper class women may be the reason connected with poverty and domestic violence reporting. So there are a lot of different categories, which is hitherto unacknowledged category of violence came as part of the PWDVA. The nature of domestic, the typology of cases, the nature of domestic relationship, of domestic violence cases fall into many times. So the nature of cases also varies. The relationship between family structure and the vulnerability to violence against women is emphasized by arguing that patriarchal, and patrilineal families in India increase the vulnerability to violence. In a large number of cases filed in front of the SPCs, the wife is the complainant and the husband or his family are the respondents. There are researches which proved the sexual assaults by intimate partners occur 2 to 8 times frequently compared to encounters with strangers. The SPCs also have taken into account cases filed by the daughter against her father, niece against her uncle, mother against the male children. So cases have also been filed where a complainant is second or third wife as well. Court has faced the contradictions where when it comes to the Muslim personal law mandates that the women who have been given talaq to leave the house of the husband under the section 17 clause 2 of this act, where the divorced women shall not evict from the shared household. So there also have been instances where the stepmother and the adopted daughter approach the SPCs and the court as complainants. Many women who approach would have run out of options. Many hope that filing a complaint might solve their issues. I use a quote here, one of the narratives here from one of the complainants I interview. 1 or 2 beatings are fine, but more than that is beyond physical endurance. Please get me a divorce in some way or other. This is beyond tolerance. Jury tried to call and talk to him once. Perhaps this will get better with that. So very desperate kind of, so many expressions you can listen while you're sitting at the SPCs. So there are more common ways in which complainants commonly word their needs. They cut across different socio-economic backgrounds, possibly due to a location of Kozhikode SPC. A good number of cases came from coastal belt. Many cases came to public, to mediators, family counselors, service providers under the Act. But it is obvious that the cases are underreported in the compared to the incidence of domestic violence. Reported cases are very much cases are reported in a very relatively less number. Women often have to consider economic and emotional dependency in case of rearing children, alternate housing, personal safety, which act as excuses tolerating the negative behaviors of their husbands and partners. So there are multiple forms of violences. So it is not possible to make any socioeconomic classification on the basis of nature of violence. Verbal and emotional violences are equally present in all groups, and while its nature and form might vary, physical violence is also similarly widespread. Increase in economic violence is observed to be proportional to the economic status. It is observed to be more in relation to property and goal than in relation to maintenance. There are many complainants who say that even if they are not provided maintenance, it would suffice their gold was returned to them. So while complainants are often reluctant to disclose instances of sexual violences, the experience at the counseling centers point to an increase in the incidence of sexual abuse of children within the family space. However, the guardians are often reluctant to bring these instances to the court. Many consider these as part and parcel of the institutions. On being informed that non-consensual sex within the marital relationship also comes within the purview of sexual violence. Though Indian Penal Code is not approving marital violence, marital rape as a category, but domestic violence, domestic PWDVA Act is the legislation which is probably not directly, indirectly recognizing the non-consensual sex as sexual violence within the marital relationships. There are quite a lot of narratives. One could explain it further also. How desperate women are when they are approaching the judicial system. So they come through a lot of hurdles before that. Within the family, there might be a lot of conciliation processes happening, a local mediation, then vigilance committees, and then finally when they reach to these police stations and counseling centers. So often the solution sought through financial settlement. So in the material struggle for livelihood, money for the pains of the physical and emotional violence inflicted. With children as bait, settlements are often forced upon. And while at least half of such settlements lead to further violence, the petitioner perceived them as interim reliefs. They choose them over shelter homes. So there are quite a lot of experiences. Say, for example, one person, he killed his father-in-law, and he went to the jail, and he's coming back to his wife's house, where the wife whose father was killed by her husband, and she was so scared because she actually gave evidences against her husband, and she was the witness for the prosecution. And then she approached the court under PWDVA for the protection. Then the response of the court was like, okay, you lost your father, you don't want your husband as well, at least you get the protection of your husband. that's what the court's responses is in such cases. So like one could cite n number of examples like that. In another situation where this the she is a student, master's students, and she was under domestic detention because the family wanted her to get married. She wanted to study further, and she approached the court for appearing her examinations. So the family wanted to get this girl married off against her will. Then the response of the court was, um, like, examination you can write it later as well. Why you want to make your parents in a painful situation or hurt their emotional sentiments? So there are a lot of situations we can see that how the response of the courts, which actually kind of eh, taking a very strong patriarchal position, as well as at times very paternalist as well. So the complainants can vary, but they approach a species for protection from sale of the shared household or prevention of second marriage of the spouse, protection from forceful custody of the child, protection from being thrown out of the household following talaq, protection from marriage without consent, or to ensure continuing education of the child. So all this show that the domestic violence prevails in its varying forms within the family structure, that its presence cut across the socio-economic concerns. So the courtroom experiences, I would like to focus a bit on that. It's more so whether it's a space of solution or a space of humiliation. Even though government has set aside a considerable sum of campaign on PWDV Act, its benefits are not easily accessible for everyone. This PD disposal, easy procedures are the watchwords of this PWDV Act. So free legal aid is provided to women who approach SPCs. Even so, there is considerable reluctance to complain on part of the women. Both social conditions and the courtroom conditions are responsible for this reluctance. The women who approaches the court is still seen by the society with the tone of accusation as being someone who complained against her husband or father or son. Most of the women approach the court only as a last resort. That is kind of, I would say, it's cutting across of all intersectionalities and all other categories, I would say. Is considered as a last resort. So let's see how the court, that should ideally be a space of comfort for women, treats them on the basis of courtroom experiences during probably last 17 years. The contradiction between the traditional character of the court and the progressive nature of the act, it's not decreased these years. And as we see, most of the progressive legislation, we know that there must not be that much opposition from the society or opposition even within the parliament when it came to existence as a legislation. Say, for example, the legislation starting from the abortion legislation, if we look into the parliamentary debates, you can see that there wasn't any religious or other oppositions against medical termination of pregnancy act in 71. And when it's come to 2005 legislation, which clearly states the mandate that it's a bias, the bias towards women, and the Posh Act also. But when we see the practical lower court experiences, we can see that a lot of like when it passed, it wasn't opposed in that way. But when it become practically a successful legislation, when women start using with their agency as petitioners, then we can see that a lot of resistance comes from within the society, within the judiciary, even the practicing lawyers also. So they see that women are becoming more powerful with the legislation, then the resistance become more intensified. So which is very true when it comes to Posh Act and PWDVA as well. So the whole campaign, a whole popular campaign against when women become the petitioners, always there's a question mark, and they have to prove their legitimacy as a complainant. So their locus standi, they have to prove that they are legitimate complainants. So in any of the other cases, you don't have to go through that double checking from the society. Are you a legitimate complainant or not? Whether this case is really there or not. So this kind of a campaign against such progressive legislations become more and more intensified. And I think there's a proportionate relationship between this resistance and how women are intelligently using these acts as a tool to address their everyday life sexual abuses and other violences in the domestic and the working sphere. So I would like to come to the second part of this presentation, where I would like to discuss bit of cases. So as I mentioned about the how the judicial officers responded to the question of wife beating, which is a kind of it. I don't know how far it's not clearly still 2021 is now how much their attitudes changed. We don't really, it's not reflecting in their judicial approaches. So there is not even a bench in the court for the complainant to sit when it comes to the real complainant scenario. This is a context in which courts are to be evaluated, how the judicial approach. And if the complainant goes, there is not even a space for the complainant to sit in the court. Nor there are any primary facilities like drinking water or toilets. The domestic violence cases are listed in maintenance cases. Hence, they are taken into consideration only towards the end of the day's procedure. That means the entire day they reach the court premises around 9 in the morning, and they have to wait till end of the court procedures are about to close. And after even petty cases are considered. So the complaint perhaps accustomed to their negative lived experience, bitterness of their lived experiences, slowly come into terms with the inhuman conditions in the court premises as well. But the wounds that they left by the injustices inflicted upon them by a space where they seek justice go unnoticed. So the cases of domestic violence are considered by the court usually like non-APP days where there is no APP, assistant public prosecutors are there. So the trials become kind of, as all the maintenance cases are considered on the same day, the importance given to the cases will be less, and they are considered only within the technical framework. The trials become impersonal affairs, and the court turns a blind eye towards the gender insensitiveness that crops up in the cross-examinations. There are a lot of experiences probably I could suggest in this paper. And one I would like to narrate now in front of you. This is a case, the petitioner is a guest lecturer at the IHRD. She had sought refuge her parents' home following multiple levels of abuse from her husband. Even after that, she was subjected to death threats, her money forcefully appropriated, debts incurred upon her. The husband took the custody of her 2-year child forcefully, and even Facebook was used against her for her character assassination. So it is in the context she approached the SPO. She sought immediate interim order directing the respondent first not to commit domestic violence, second not to enter petitioner's residence, third not to enter the workplace of the petitioner, and finally not to use social work spaces to defame the petitioner. To this, judicial officers responded sarcastically. I quote here, do you need an order to deport the respondent from India? Is he not after all the husband of the petitioner? This is what the judicial officer is asking to the lawyer who is arguing for the petitioner. This offhand comment by the court was prior to examining any of the documents, including the printout of Facebook page and 12 other documents submitted before the court. So on leaving the courtroom, the complaint was witnessing the entire process, and she was asking to the lawyer, is it possible to change this case to some other court? How can the court handle my life and its pain so casually? Why should I get hurt for not having an option but file a case? So this, I think, is not a unique case. This reflects the characteristics of the entire nature of the pain which complainants goes through in the lower court when it comes to the domestic violence cases. So how the courts are acting is another concern. There are numerous examples for the gender insensitivity of the lower court in dealing with the cases of domestic violence. There was a case where the respondent was responsible for the death of the petitioner's father, which I mentioned before. So then even the restriction order, court was reluctant. And the court was asking, the judicial officer was asking, isn't his life a life? So the lawyer of the petitioner is supposed to ask, what about the life of the petitioner? So the response of the judiciary is like, it should be okay as they have been living as couple. So kind of reinforcing the sacrosanctum of the marriage and the family. So I probably, lack of time, I won't focus more of such cases. You can see a lot of cases with the same or similar narratives of this kind. And as I said, the cases which is approaching the apex courts, Supreme Courts and High Courts and Supreme Court, which the number of cases are very rare. And there are certain like landmark decisions like Batra versus Batra. Supreme Court is at times takes kind of progressive positions and at times takes a very regressive position as well. So a arena of cases, Velichami versus Pachiammal, Surendra and DK and others versus State of Kerala, R. Batra versus Taruna Batra, Sunita versus State of Kerala, a lot of cases, which is, we cannot say that there's a consistency when it comes to evaluate a legislation which in letters saying that it's biased legislation towards women, but the judicial approach is not really reflecting that approach. So how much time is left, Fascia?
Well, take as much time as you need to finish the paper, Arathi. As your chair, I will give you that leaving.
Okay. So let me just little bit elaborate the apex court of judicial interventions from like to see how vis-a-vis the lower courts, how the apex court functions when it comes to domestic violence cases in India. Judgments made by the apex courts are binding to the lower court decisions based on the principle of precedence, we all know. When it is suggested that 2 weeks of living together cannot be considered as cohabitation, and women in such relationship should be considered as a keep, I use quote, as the common law marriage ingredients are lacking, the provision given in section 2 clause 5 of the Act for person who lived in marriage like relationship becomes irrelevant. So the finding that the person involved in relationship that has been declared null and void cannot file a case of domestic violence also weakens the section of 2 clause F, which clearly says that person who lived in marriage-like relationship is also entitled to file a complaint under the PWDVA Act. But the judicial approach of the apex court also is not really recognizing the locus standi of such persons who lives in marriage-like relationships. The well-known judgment, which in Batra's case laid out that the daughter-in-law has no claims on shared household if the household is in the name of mother-in-law, renders more than half of the female population of India without the claim to a shared household. The scope of Section 2, Clause F, is thereby restricted considerably by the apex court decisions. The judgment that interim ex parte order is only needed in extreme situations and that in other cases notice should first be issued to the respondents. And there are the lower courts that adhere to this character of the apex courts also issues judgment. I use a quote here, considering the material facts and weightage of evidences. These naturally raise doubts on whether gender sensitive legislation can survive in such a judicial such nature of judicial processes in both lower and apex courts. So let me wind up to look into, can we see how we analyze the success of PWDVA. The feminist scholarship in India tries to explain violence in terms of patriarchal society as a method of controlling women who have subordinate status. The experiences of organizations that work with victims of domestic violence reveal that it is hard to pursue court cases. I quote here, the policies are biased and evidence is not preserved and judges are unsympathetic. Even women in a hospital try to protect their husbands because of the shame or because of children. In Kerala High Court, one of the judgments by Justice Ram Kumar, he stated that domestic violence is a human right violation. It's in Vijayalakshmi Amma versus Bindu V and another in 2010. The act needs to be implemented properly so as to effectively address these instances of human rights violation, along with other laws that protect the rights of women. The act helps to raise their status within the family and harmonize existence. However, the act is not digested easily by the strong within across the strong patriarchal systems like the entire administrative system, court system, and within the family structure as well. Even the official statistics show that one woman is attacked in her household in every 20 minutes in India. If the act is reduced to the current stature, for instance, the Dowry Prohibition Act of 1961, which is hardly made use, we all know that. And what then could ensure support to these women? An empirical study from the Bangladesh by Naved and Person is based on data generated by population survey and in-depth interviews, identifies rarely enforced dowry laws to be it's very common in Bangladesh like in India. Both share, we know that's a colonial past and patriarchal social environment. So the study indicates that like in India, in Bangladesh also, non-payment or partial payment of dowry triggers domestic violence. I just would like to add one more thing here. Now, again, every state is discussing about making amendments to the Dowry Prohibition Act. they're discussing now in the direction of giving more power to the dowry prohibition officers, where none of the complaints is registered in many of the offices for years. But at the same time, nobody discussed about importance of probably strengthening the PWDVA Act in the context of domestic violence. So the family structure is potentially important factor associated with violence. In the given context, the restrictions and limitations withstanding the Act was able to define the hardships and violence endured within the family space as domestic violence. It breaks the value system that normalize such acts. While the value of the most of the judgments is only on paper, it has helped a number of women to face certain critical junctures, and thereby it has strengthened them to face the life ahead. Like the work of Rekha Mirchandani, examines how the state promotes the male dominance through its institutions like courts. The feminist critique of the state is fundamental to the critical analysis of legislation, implementation, and interpretation of laws. She argues that the masculine mode of argumentation may inhibit women's ability to speak or to be heard. I quote here, those who Rekha Mirchandani here, those who see patriarchy at the core of domestic violence have worried that the state response to domestic violence would result in the reproduction rather than amelioration of patriarchal culture in the home and in the state. So hence it is important to discuss the impact of domestic violence legislation in everyday courtroom experience to understand impact of law on violence in domestic space. The enactment of PWDVA is one of the major achievements of women's movements in the post-independent India, I would argue. However, its implementation has many limitations as discussed in this paper. The work of Flavia Agnes criticizes the trend in the activities of women's movements in India, which are always oriented toward bringing in legislation which protect the rights of women in papers. After the legislation gets passed, it is invariably criticized by the women's movement that as not bringing any change into the lives of women because of lack of proper implementation. So this is the first time where there are avenues for movements to be part of implementation and evaluation. The OAS Collective used to do the evaluation for quite long time. And in the implementation level, in terms of service providing centers, SPCs are run by a lot of women's organizations and the women's NGOs. So the implementation process also, there's a space created over there. So the analysis of implementation of PWDVA is relevant in this context. The inquiry in this paper, which revealed that it has not created much improvements in the life of women in terms of preventing familial violence. But the act made an attempt to acknowledge many levels of violence which were never considered before as violence in many of the instruments of the state. Say, for example, emotional violence or a financial violence. These are the categories never been kind of recognized as categories of violence before. Since the act itself is bringing this category, the instruments of state also started recognizing such categories of violence. So the space created by this act opened many avenues for women to access different systems of justice delivering, like service providing center, police stations, and courtrooms, thereby giving them exposure to otherwise male spaces. So they could have never approached a court if PWDVA wouldn't have been there. So this exposure in a way help women to challenge many injustices they face on a day-to-day basis at different facets of life. Going through the whole process of reaching the service providing center, from there to filing the case, to the humiliations in the courtrooms and the police stations, provokes the complainant, the women, to think on the alternatives to this and the limitations of the legal system. We know that all sort of kind of uh, violences, which is basically it invokes from the lack of democratic nature within the relationships. It's very limited role of law to address these violences. But going through this process of in the status of a complainant, I think that gives an opportunity to realize the futility of this entire, or not, I wouldn't say futility, but the limitation of the legal system. So I think this may help women to think about in an alternative way of dealing with everydayness of life through the movements or through seeking other avenues, other possibilities of collective nature, which aims for structural changes. So other structures, the protection officers, service providing centers, legal counselors established by the PWDVA, to an extent cater women not to fall in a desperation or negative frame of mind that they are somehow catering. So the act has created a category of women oppressed but able to resist. So that's what I argue in this paper, this category of women oppressed but able to resist. At the same time, the very nature of PWDVA, we can say, many of the feminist scholars argue that it's kind of a state vanguard of the family. So I'm not entering to that argument here. Probably I too agree to an extent to that. But I think this creating a new category of women oppressed but able to resist through this legislation is important. So I would like to conclude that the feminist debates on the nature of law, whether it can be used as a tool to change the life of women, or whether the law works as a tool to oppress women, is a very complex debate in a patriarchal, class-divided, caste-oppressed society like ours. And the lower court experiences of PWDVA reveals that complexity. Thank you.
Thank you very much, Arathi. That was extremely interesting, comprehensive, and engaged many difficult and important areas. Now, for those who are familiar with not just the history of the PWDVA coming into being and the kinds of issues around domestic violence, its definition, the issues that have been raised by the women's movements about this, and the complexity of the relationship of law with everyday forms of justice, especially in instances of violence against women. Most of us are kind of familiar with the sort of complex picture that Arathi was presenting here before us, which is to say that there is no easy way of either reading the law or looking at its outcomes. It's not like a NAC report, in other words. I mean, you cannot sort of enumerate a number of things and say, well, you have all of these kinds of features in the law, and therefore these are the kinds of expected outcomes and so on. It's far more difficult, and it's an ongoing struggle. I had, in between, as the talk was going on, I had noticed that a student of mine who has actually written an excellent thesis on the Domestic Violence Act, Prevention of Domestic Violence Act, had joined the meeting, but maybe she's got voted out, online systems being what they are. I hope she comes back, Himalika Mohanty, and I hope she would engage you on this. As Fasha had announced in the beginning, we would greatly appreciate it if people who have questions will type in their questions into the chat box. We will read it out so that everybody else can hear it and the speaker can respond to it. In case there are people who have great difficulty in typing into the chat box and online systems are unfamiliar, please use the raise hand option and I will call upon you once the typed in questions come to an end. So let me just start, Arathi, off. I have various things to share with you, but we can keep that for another time, or perhaps later, once people have started asking their questions. But I was curious to know that, in this period, the kind of checkered history that you were tracking of the way in which, there are, one of the things that we know is that when women are at the receiving end of violence within familial contexts, and be it intimate partner, spousal, or other kinds of familial contexts, they do not go rushing off to the police or to the courts. It takes the journey between being, people who, whose bodies bear these scars and whose bodies that have witnessed in so many complicated ways to such violence, and to their seeking justice in the formal sense of seeking justice in the courts, is a very long one. I wanted to ask you a slightly different question, which is, has this come up for discussion within the context of women's groups and feminist groups in Kerala, taking up the way in which there is this disconnect between a pretty good law existing in paper and the absence of its utilization by women? Has this become an area of discussion?
Yeah, I think that has been, I am not very actively participating with many of the groups and all, but whatever I gather, because when I went to do the field work, I've interacted with many of the like women's rights activists and feminist scholars as well. So we can see that the initial in 2005 itself, there was a gathering where different women's groups came together, and they were discussing about how to implement this, because every time we talk about any progressive law, always the hue cry about the implementation part of it. Here, this is one legislation where there is a role for the movements as well, to be part of it as service providing centers. And we know that most of the, say for example, in Calicut, Anuashi used to act as a very strong service providing center, and the service providing center I was part of, where Savitri teacher was leading that. She was one of the leading women's rights activists in the city. And all these activists were kind of trying to be part of starting new SPCs and are demanding with the government also. In 2005, how to implement this act effectively. And in Kerala, the women practicing lawyers being appointed by the government is part of the strong articulation from the different women's group across Kerala. So they all came together to discuss. And I think the major, probably how to create support systems and continue, like how to become a petitioner itself is, as you said, is a very painstaking process. And once you become a petitioner, definitely, because she's there because the family structure is not at all supportive. So when there is no family to support, who can be a supporter throughout the litigation period? And even after that also might need some level of support. So creating such support systems, I think a lot more to do from the women's groups, and even in general, the political parties and other groups, they can think of, and even the role of Panchayat Raj system in Kerala, which is to an extent try to develop such systems through the vigilant committees and other supportive systems. I think that needs to be strengthened so that a person, say, or a victim or who has a complainant can become a petitioner and that petitioner can fight the case in the court and live a very decent and dignified life after that, also a meaningful life. So to ensure that as a social process, I think a lot more to do by all progressive forces. I think that's not only the responsibilities of the women's group. The entire, those who are standing for progressive credentials, they have the responsibility, and state also share that responsibility.
Anyone with questions? If people feel that it's difficult to type in, could you please use the raise hand option, please? Naveen Philip. Naveen Philip, will you?
No. It's Mridul. I'm.
Ah.
It's Mridul Epan. I'm actually. It's my son-in-law's thing. So it's. So I'm going to ask the question. I didn't know how to remove his photograph from there. So the question to Arathi. Two things I wanted to ask you. One is, this. You made a statement that because so many of these cases are linked to dowry, this act could be strengthened. That's a very important statement you made. In which way can the act be strengthened? Because all the dowry cases that have happened till now, none of them use this act. I mean, it was all through the dowry thing that they were. All these 3 or 4 very, those horrible cases that did happen in Kerala. So that is one thing. How do you strengthen this act to enable women to use it in case of dowry harassment? That's what I'm asking. That's one thing. The second thing you said was, it has enabled oppressed women to react, or some such statement you made, that women are oppressed, but they're still able to, what was the word you used? I'm sorry.
Resist.
Resist. Now, are you saying that because it actually opened an avenue for, in a way, women who would not have gone to the police station? There are lots of women who would not go to the police station to file a complaint, but because this is a civil act in a certain sense, you go to the protection officer, many more women could actually access it. Is that the way you meant it? Or in general, you feel that it has enabled women to resist? So that was the second question I wanted to ask. And third, quickly, I'll just say it. Why, in your opinion, are women using so little of it? An act which is so much in favor of women, and actually it was drawn up by women also, women lawyers. That's what I remember reading at that time, that it is not being much used. So is it because it takes its own time? It's not being interpreted as it should have been interpreted? Is that the reason? Or why is it that they are not using it much? You answer whatever you can. I mean, I'm just asking you all the doubts I have been having in my mind about it.
Thank you, Mridul. And let me just probably I need to think a bit more on how the PWDVA can act as to strengthen it, to prevent the probably minimal usage or lack of usage of Dowry Prohibition Act. Like we know that we have prohibition officers, and no cases being complained under Dowry Prohibition Act, and then eventually decided to, in Kerala also decided to close down such offices because there was no complaints coming in. And there are problems with Dowry Prohibition Act because where both the sides are committing an offense. Those who giving and taking, both is considered as an offense under Dowry Prohibition Act. That itself is one of the reasons I think there was a complaint coming out of it. Whereas PWDVA, which is clearly recognizing categories of financial violence, emotional violence, where this transactional relationships as part of the dowry and the violence is coming as a package with dowry, can be considered as this under these categories. So I think in terms of when a popular dowry case happening in Kerala, then the administrative level thinking goes like how to strengthen the capacities of prohibition officers to implement Dowry Prohibition Act in an effective manner. But the basic character of Dowry Prohibition Act itself is prohibiting to use that act as a tool, because the giver is also considered as an offender. Whereas PWDVA Act opens an avenue where under financial violence or emotional violence or all those categories of different violences, this dowry, whatever is happening in the name of dowry can be can become a complaint, a part of the complaint over there. But the thing is that the limitation of PWDV Act, we know that there's it's not a criminal it's a civil legislation, and the offenses are considered not in a the punishments are not as grave as when it comes to if a Dowry Prohibition Act is implemented or in a successful manner. But my point is, PWDVA Act recognizes categories of violence where a person who is aggrieved of a situation of dowry violence can be a strong petitioner, whereas Dowry Prohibition Act is not really giving that locus standi of a strong petitioner, because that person become an accomplice or a co-offender in the situation of Dowry Prohibition Act. So to address the issues with the Dowry Prohibition Act, I think this is one of the ways in which we can think of strengthening PWDVA and address this financial violences, emotional violences together. And your second question is about the categories I've used here, like women are oppressed but able to resist. I think I narrated at the end in a bit, but probably I should explain it further, because it's not about whether it's a civil nature or not. The SPCs or police station also women go with the complainants, but the experiences of probably last 17 years and the lower court room experiences, which is indicating that as a complainant, the journey they go through, like going to the SPCs, talking to the counselor over there, legal counselor over there, and then at times go to the police station and make complaints, and then face the courtrooms where it's completely a male space. So all that experiences of as a complainant, probably even if they're not able to get justice out of the entire petitioner being the petitioner, and cases they might lose also, but that process is actually one way make them to understand probably the limitation of law, because they came and then they approached the entire use of PWDV as a last resort, and then they realize this last resort itself is not really helpful. So then that creates kind of a different level of energy of resistance. It's not desperation. So that's what the experiences I've interviewed with the lawyers who are working for arguing mostly for the petitioners. They say that there are many cases women lost the case, but they become a different person altogether, not the person who came before them as a complainant. But the process of entire part of this judicial process and this entire bureaucratic process and the courtroom experiences, the kind of humiliation they face in the courtrooms is not really making them vulnerable. That's why I think SPCs are important here, because they give kind of a support system not to completely let them down also. So that's why I said, I think in the, especially, I'm not extending that argument in the entire pan-Indian context, but at least in Kerala context, the way SPCs are functioning and the especially the presence of women lawyers, most of them are quite sensitive about these issues of gender-based violences. So they're creating a support system The only thing is like how far we can strengthen that part of it. But the experiences of lawyers and the courtroom observation I have done, which clearly says that it's not the same person who came with a complaint is leaving the entire process. They, as litigants, I think they kind of go through a lot of struggles, and that struggle is, even if they are winning or not, they are developing a kind of resistance towards violence, and their tolerance level towards the violence is going really, they are pointing it out that there are many narratives which, as part of my work, which clearly says that though it's not matter whether we won or not, now we know how to live in this society. We learn that. So that is, I think, a different experience, no matter whether it is a civil or a criminal law. Then coming to the question of reporting less and fighting less, I think all the factors which is coming in, how the society is looking to a matter of complaint. And in Kerala, I would say that a lot of mediation processes are happening when it comes to interpersonal familial violence. Starting from the neighborhood groups, political parties, panchayat members, they're all acting as kind of alternate dispute redressal platforms. Many of the, I'm not quite sure that how gender sensitive are those platforms, and their community-based platforms also acting as alternate dispute redressal platforms. So the political parties, panchayat systems, different kind of community groups, they're all acting, and within the family also a level of alternate dispute redressal platforms are functioning. I think that that's become one of the reasons in which the number of complaints are not really coming in good manner. And then the entire painstaking process of being a litigant and how the society is looking into that, and a lack of support system, everything that matters. But even the statistics clearly shows that the number is increasing in terms of complaints.
Thanks, Arathi. Yeah, thanks a lot.
In the chat box, Arjun has shared his concern. You discussed about desperation among women to approach judiciary. You mentioned about shelter homes also. Let us suppose that a woman, due to various forms of domestic violence, approached judiciary and gained her right to freedom. Then, where will she go? That means, are our government shelter homes efficient enough to accommodate such women in a healthy atmosphere? And for how long?
I think PWDVA is unique in a way because it won't allow a situation where the in-laws family or the petitioner's own family cannot let the person out of the house or throw the person out of the house. Even for the shared household also, there is a right to stay in the house. And that is actually reiterating in the PWDVA. Say, for example, even they can get injunction order if a woman is staying in with their in-laws and the husband's family. She can get. There are a lot of instances. Petitioners used to get injunction order so that the violent husband cannot enter the household, even if it's husband's household. So shelter, before we think about the shelters, I think wherever they are staying, there is the act is actually entitling women to stay safe within their own household without facing any violence. The violent person, through injunction order, they have to stay outside the house. So that is there. And shelter homes, I think I haven't mentioned about shelter homes. Probably, I don't know about the government shelter homes and all, but the act itself is opening an avenue to continue to stay in their own houses or in their husband's house. Even if the husband is acting violent, she can get an injunction order to get the husband out of the house. and continue to stay. There are quite a lot of injection orders are happening everyday basis. So I think before we think about the shelter homes, I think it's important to understand the law creates a space to continue to stay in their own houses or their husband's houses. So if she opted that, okay, I don't want to continue to stay with this person at all, then probably state shelter homes are available. I am sorry that I'm quite unaware of what is their status and how safe they are and all. I'm sorry.
Next question by Gopal Krishnan from Delhi. It is based on his experience from a Delhi slum. The woman is constantly a victim of domestic violence. She has a teenager daughter too, but she's not ready to file any complaint just because of the fear of a divorce, which might cause problem for her daughter, who is a bright student in school. No one will support her in life once she moves out of her home, she continuously says. She lives in one of the poorest of the slums in South Delhi. I too feel very helpless in front of her. How do you react?
I think this paper, I also thank you, Gopalji, and I in this paper from our experience in past 17 years in Kerala, which also same, the working class people, they don't have any other source of income to support the study of their children. That's where women used to compromise in terms of future of their children and continues to tolerate this violence. That's one of the major kind of a, I would say it's very common feature. So I think it's important to think about how to financially make situations better for such people and take care of the public schooling system. We don't like we tend to see things in isolation. We don't see the political economy of violence also, because when women have their own standing and income, they don't tolerate this violence anymore. And when say for example, if the kid the education of the student their children, we don't speak about universalization of education or universalization of health system when we talk about the question of domestic violence. So we don't have systems where right to education is not ensured. And how do we see it in watertight compartments? On one side, education of children is not entitled or is not provided, and the other side, the violence continuing and the toleration of that violence become a compromise for better education of the children. That's a very, very common phenomena cutting across. It's not about not merely about the working class condition. It's very prominent in middle class as well as upper class, where women opted not to work for the future of the children. And at some point the violence becomes so intolerable and the women is completely out of income or self sustainability, and to compromise within the violence this violent family for the betterment of the children. So that become kind of a vicious circle in such upper class situations, whereas working class situations, I think we should understand this political economy aspects of violence. I think I don't have clearly solutions for this, Gopalji, but I think we should understand it. It's in the larger framework and think about solutions from there, rather finding a simple way, probably shortcuts for such situations. Thank you.
Arathi, I'm going to take advantage of the fact that there aren't any other questions at the moment. Maybe people are typing in the chat box to take your attention away to the question of counseling. because that's a really difficult problem. And one has often found that, it's not, here, you were speaking about the ways in which the SPCs are the ones that are involved in counseling and so on. But as you know, women police are also encouraged enormously to counsel and so on. So what do we do? I mean, firstly, is there any good ethnography of counseling itself in the context of violence against women? Do we have anything that we can read and get to understand this a little bit more? But that aside, who is being counseled and who counsels, and what are the sort of conditions under which this entire exercise of counseling takes place? Could you talk to us a little bit about that?
Yeah, there are works also discussing this, how this entire counseling session is reiterating patriarchal values and the importance of family. So how this judicial decision in 2015 by Bombay High Court, that's also discussing the nature of this counseling, how that process of counseling itself is another torture or another way of conducting the violence. There are case laws itself discuss that. The work of Gopika Solanki and Geetanjali Ganguly in 2015, they based on the Mumbai High Court decision, they are discussing that aspect of it. How this kind of women's autonomy is actually questioned in such process of counseling. In SPCs, we know that there is one psychological counselor is also coming in a weekly basis, and basically the counseling is legal counseling happening in SPCs. The petitioners being heard, whoever is complainant at that stage, being heard properly, and then giving them suggestions, because the PWDVA is something new to them also, and probably one complainant is coming approaching the SPC for physical violence, and then we understand there are other categories of financial violence and emotional violence that's also involved in it. So even to identify them in different categories of violences, I think to an extent the counseling is helping. But I'm not generalizing. There are, as you know, might be situations where I witnessed one of the very progressive women's group. They are conducting counseling, and their counselors are forcing women to going back to the family for the amicable settlements. So definitely the popular notion of family, the sanctity of marriage is everything reflected, and think about the future of their kids has become one of the elements to going back to the family and for amicable settlements. But most of the I won't say most of the, but if the lawyer, the practicing lawyer as the legal counselor, if she is sensible enough, we can see that a lot of complaints being sharpened and coming, placing them to the different categories of violences and filing a DIR, ending up in the court cases and fighting for that. So I think it's a mixed kind of a situation, but mostly the counseling happening as part of the PWDVA in SPCs are legal counseling, not the other psychological counseling. So, yeah.
Anybody else who hasn't typed in a question who wishes to ask at the moment?
Arathi, I have a simple question. Do problems like domestic violence change after doing family counseling, in your observation? And and one more to be added. In usual family counseling, a rapport must be established between the counselor and the counseling. Usually in the psychological family counseling, not in the family court. Actually, is this going on in the court? Is there any chance to establish a rapport between the counselor and the counseling?
Actually, I think the nature of violence also varies, right? A lot of categories of violence involved, and a lot of complex situations also come, used to come under the PWDVA. And there are many situations, as you said, it's very difficult to have to build a rapport or to have an amicable, even a dialogue between the parties. And there are many situations I observed that it's even difficult for the complainant to open before the legal counselor to discuss about what had she has been going through. It's even very difficult to open up that. And but there are situations where there could be some level of misunderstanding that could lead to a complaint. So in probably such situations, if the counselor tried to help the complainant to understand the other side of it, then might be very rarest of rare cases, we can see certain kind of amicability coming into. Otherwise, it's very, very difficult to create that rapport, because as I argued in the paper also, that's most of the cases is the last resort, and they've tolerated there enough. And this is something they don't even have the voice to say no, but they are ready to come here. They might have said no many a times and it's not being heard properly. So then they're coming to as a complainant. So in such situations, it's very difficult, and this entire process of counseling is itself become very, I would say, futile to an extent, and it's kind of institutionalizing the kind of an essentialization of family happening through the sanction of law in such situations of counseling. Many a times we can see that as well. I'm not saying that all the time it's beneficial for the complainant, but many a times it forces women to going back to the violence, going back to whatever judiciary I have discussed in the paper. Counseling also, we can see a replica of that. I'm not saying that every time it's very progressive, but we can see that a lot of situations, many of the fabulent lawyers, sensitive lawyers, they are helping the women complainant to be a petitioner. That's something which is, I would say, as a positive remark. Rest is whatever gender stereotypes and the patriarchal values is being reiterated through the counseling, through the judicial interventions. That's what the paper basically trying to expose.
Thank you, Dr. Arathi.
I think we've come to the end of all the questions in the chat box, Arathi. So unless there's somebody who suddenly jumps in, I think we've come to the end of this very important session. I have a feeling that what happens usually is that these discussions are for the most part, in more recent times, at least in my experience, it's within context of gender and women's studies departments or feminist legal scholarship that these discussions take place. Academic discussions of this kind are usually held within those kinds of departmental contexts. And you don't normally have a so-called non-gender specific kind of academic context like a historical research council or a history department opening itself up to these kinds of discussions. So I'm very happy that there's actually quite a wide range of people who attended the talk. And sometimes it's not only about questions that are asked, it's also about familiarizing oneself with the kind of debate. So thank you so much for laying it out so clearly. I think it's a important way to introduce people to the fact that there has been, apart from legal interventions and political debates and discussions within women's movements and so on, I think it's also important to remember that there has been enormous amount of scholarly thinking and rethinking around these issues. And even though the PWDVA came as a part of a response of feminist legal studies people and feminist lawyers and so on, in sort of conjunction with others, I think it is also very, very significant that subsequent to that, there has been a lot of reflection, ongoing reflection on whether this has been working. And I think the Kerala experience, therefore, was very interesting for me to hear, because most of the time, the kind of information that one has access to comes from other parts of the country where the nature of the state or the state government's kind of interventions might be quite different. So it's interesting to think about, the areas of commonality between Kerala and other parts of the country when it comes to questions of violence against women. But also it's important to think about what has been made easier here. And I think to that extent, I think your talk really laid that out very clearly for us. So thank you so much. And I thank everybody who has been part of this session. Do come again, and Arathi, do come again and share your work with us. Thanks a lot.
Thank you. Thank you all for the questions and the platform. I'm thankful to KCHR and the participants today. Thank you so much.